first, or are you going first?
And on the we didn't have possibility so far to discuss the order of pleadings.
Right.
However, if that fits claimant, we would propose that respondent begins on the jurisdictional part, followed by claimant and respective rebuttal and surrebuttal. And on the merits, it would be the claimant that begins, followed by respondent and respective rebuttal, surrebuttal.
Yeah.
We agree.
Of course.
And members of the tribunal, we have agreed on a time allocation between us. The speaker for jurisdiction will speak for the speaker for jurisdiction. For respondent will speak for 17 minutes,
Okay.
reserving 1 minute for rebuttal. And speaker for the merits will speak for 21 minutes, reserving 1 minute for rebuttal.
As to the claimant, we will be addressing the jurisdictional issues in 19 minutes, both, and the merits also 19 minutes. And each respectfully reserve 1 minute for rebuttal and surrebuttal.
Sorry, just to confirm, respondents on the merits, you said 20 minutes for
21, I think.
21.
Reserving 1 minute.
Perfect, thank you.
And how long for rebuttal on the jurisdiction? 17 minutes?
17 minutes
And
plus 1 minute
one.
for rebuttal.
Always not picking up people for.
Mhm.
It's not getting.
Mhm.
Is Dugas the name of the team for the claimant? I'm just looking at the.
Yes.
That's the name of their team, and you are Team Bauer.
Yes, exactly.
Yes.
Precisely.
Yeah, I think if everybody's ready, we can get underway.
Shall we start? Yes. So we're going to make a start. Welcome, everyone. Thank you for being here. This is the final, as you know, of the FDI Moot 2022 edition. My name is Sophie Nappert. I will be chairing this tribunal composed of my co-arbitrators, Lucia Vilaseca and some Wordsworth, and we are the arbitral tribunal. I am delighted to have before us Team Dugas for the claimant remotely and Team Bauer. I will ask simply that the team members say who their names are, just for the record, and also to allow me to pronounce them correctly in due course. For the claimant, please, would you please say who you are?
Members of the tribunal, esteemed opposing counsel, good evening. My name is Anna Gavkalu, and I will be introducing the jurisdictional objections of the claimant.
Thank you.
And my name is Elizaveta Shtykhova, and I will be presenting the merits of the dispute.
Thank you very much. For Team Bauer, please.
Members of the tribunal, the opposing counsels, my name is Jan Baudyga, and along with my co-counsel, Lucia Vilaseca, we represent respondent in these proceedings, so Republic of Rhekia.
Thank you very much. We've had this discussion just before we started, but I understand, and please tell me if I'm wrong, that we're starting with the jurisdictional objection, with the respondent going first. Is that correct? on the claimant side?
Yes.
Very good. So please start with your submissions.
Members of the tribunal, as I introduced myself, my name is Jan Baudyga, and in the following 17 minutes, I will address two jurisdictional issues concerning this tribunal's jurisdiction over the present dispute. Namely, that this tribunal has no jurisdiction over the present case, first, in the light of the exhaustion of local remedies rule, or alternatively, second, in the light of res judicata rule. And members of the tribunal, before moving on to the core of the respondent's argumentation, I would like to make 2 points. First, respondent raises 2 alternative jurisdictional objections. Therefore, it suffices that only one of them applies for this tribunal to decline its jurisdiction. And members of the tribunal, the second remark is that both of the objections raised by respondent are, in the majority view, jurisdictional objections. However, being aware of the pending doctrinal disputes in this regard, we subsidiarily raise admissibility objections based on the same prerequisites, result of which is the same, so a rejection of claimant's claims. Having said that, I would like to proceed to first submission, which addresses the issue of exhaustion of local remedies. Members of the tribunal, to begin with it, I would like to invite this tribunal to page 77 of the record, so that we can see what exactly is the provision on exhaustion of local remedies saying. The Article 12 on page 77, is the tribunal with me?
Yes.
In subsection 2 states that disputes concerning this treaty shall not be referred to arbitration unless, I quote, 18 months have passed from the time that an investor submits the dispute to the judicial bodies of the contracting party. And now, members of the tribunal, I would like to stress also the third paragraph of this article, which states that each contracting party requires that the exhaustion of local judicial remedies be a condition of its consent to arbitration under Article 13. Now, members of the tribunal, it stems clearly from this provision that it is a mandatory recourse to local judicial bodies of Rhekia that is required before commencing any arbitration. However, members of the tribunal, being aware of claimant's argumentation on the futility exception, I would also like to address this issue, although it clearly stems from the provision that it is mandatory. Members of the tribunal, the purpose of this provision is to give a host state a certain period of time so that it can resolve a dispute before its local judicial bodies. And now, members of the tribunal, it is to be stressed that obligation that is included here is the one that the claimant is obliged only to submit a claim before local judicial bodies of respondent, and this provision does not condition its applicability of obtaining any award within this time. And this fully makes sense. Members of the tribunal, such provision was, for instance, already considered in, for instance, a case of ambiente official versus Argentina. And there, the tribunal stated that in such a situation, there should be no considerations on possibility to obtain an award within that time, because it is a time for the local judicial bodies to resolve a dispute in different means. It can be, and I provide examples by the ambiente official tribunal, it can be court or out-of-court settlement, or even first instance proceedings. Now, members of the tribunal, even if this tribunal would like to find that there exists certain futility here, the certain threshold has to be met. And the standard for futility is really, really high. It does not involve only improbability of timely resolving a dispute. However, rather practically zero chance of having it resolved. And to support that statement, I would like to refer to a case of ICS versus Argentina, also involving very similar clause to the one at hand concerning the 18 months period. Members of the tribunal, there the standard was set of obvious futility of remedies where the relief sought is patently unavailable. And members of the tribunal, again, in this regard, the burden of proof lays on claimant that such futility exists. As was stated in the Kilic versus Turkmenistan case, the claimant is obliged not only to provide an evidence, but to be precise, best evidence of futility. However, members of the tribunal, the facts of the case are simply contrary to that. members of the tribunal to verify whether it is possible to address a dispute within a certain period of time, within at least first instance in 18 months, we should look at a similar case before local judicial bodies of Rhekia.
Counsel, when you talk about best evidence of futility, what do you mean? I mean, the burden of proof rests on the claimant. To my knowledge, they have to prove on the balance of probabilities, to use a common law expression, more likely than not. Are you saying that the burden is higher than this?
Madam Presiding Arbitrator, to address that question, I would like to refer to reasoning also applied by the ICS Tribunal versus Argentina that I already mentioned. In that case, the tribunal stated that the sole fact of parties that are deliberating whether it is possible or whether it is not possible to obtain an award within 18 months is sufficient to state that it is not obvious futility. And therefore, if claimant is able to provide sufficient evidence, for instance, that a similar case has been resolved in more than 18 months, it suffices for the respondent here. However, facts are contradictory to that. We have a claim of Donald and Daisy, so according to respondent, identical to the one of claimant, that was already resolved before local judicial bodies of Rhekia. And it was resolved within only 12 months, when the average of resolving a dispute was between 16 to 18 months. This is severely below the average. Now, members of the tribunal, we know from the uncontested facts of the case that now the average of time of resolving a dispute in first instance is only 12 months. Now, members of the tribunal, to point out one thing. In the Urbaser versus Argentina case, which also involved a similar clause to the one at hand, the tribunal stated that to comply with it, and so that no futility applies, it is sufficient that within this 18 months period, only first instance proceedings are finished. And this is the case at hand.
How does this tribunal gauge, in looking at futility, is the length of time, the average length of time, you say is 12 months. 12 months is a long time if you're a claimant that allegedly has suffered the amount of damage that the claimants claim here. Is that a factor that we should look at? Should it be 3 months?
Madam Presiding Arbitrator, in this regard, I would like to point out two things. First one, the fact that in the jurisdiction of this tribunal and any possibility to address this issue before arbitration is dependent to the wording of the BIT. So if the BIT states that this 18 months period has to be met, then we should just follow the wording of the treaty. And this was also stated in the Ambiente Official case that I mentioned before versus Argentina, that it should not be simply disregarded. And addressing the second point that I would like to mention here, the claimant has already waited 4 years to initiate these proceedings. It had more than enough time to file a claim before the local judicial bodies of Rhekia, but it didn't. However, if it did file a claim without delay, it would have received a final award in 2 instances and probably having it reviewed by the Supreme Court of Rhekia. However, members of the tribunal, it didn't. What claimant is in fact trying to do here is asking this tribunal to disregard the exhaustion of local remedies rule. However, it is primarily claimant who disregarded it the most. Having said that, I would like to move on to the second submission.
Counsel,
yes?
if I may, before you move on to your other point, you mentioned the Donald and Daisy Award. Couldn't we consider that this requirement was already met? Because, as you mentioned, the purpose of this clause was to have the state have the opportunity to provide a solution to the dispute. And your state has already considered this dispute with the Donald and Daisy case, and as you mentioned, they complied with this requirement. So can't we apply that exhaustion of local remedies to this case and continue with arbitration?
Madam Arbitrator, we cannot apply, in fact, Donald and Daisy proceedings to the one at hand. Members of the tribunal, this is exactly the reason for which those two respondents' objections are alternative to one another. In a situation when those, according to respondent, those two cases are identical, then res judicata effect occurs and this tribunal has no jurisdiction. However, if this tribunal finds that no res judicata effect occurs, then there is no possibility to state that Donald and Daisy in fact, exhausted local remedies for claimant. And in such situation, this cannot be taken into account.
What I mean is a follow-up question. Is it the same threshold that we have to apply to consider res judicata, or if we could consider the exhaustion of local remedies for this case?
Yes, Madam Arbitrator, it has to be also a triple identity test, which I will elaborate on now. Members of the tribunal, claimant seeks for adjudicating again on a matter that has already been addressed in the Donald and Daisy case, as I stated before. And now, to address this issue, we need to look at the standard for identity of two cases. According to the case law, it is a standard of triple identity. Two cases need to be identical as to the parties, subject matter, and cause of action. And members of the tribunal, in this case, all of these three prerequisites are met in the case at hand. Starting with the identity of the parties. Members of the tribunal, what is a company without its shareholders? It is an empty jar, since those are shareholders who hold stake in the company and who influence its operation. And for this reason, the case law stated that requirement of identity of the parties cannot be considered very strictly, since it would lose its effectiveness against filing multiple claims by the de facto same claimants. And for this reason, the case law elaborated the so-called economic approach to this situation, where its shareholder can, under certain circumstances, be identified with the company itself. And those prerequisites that have to be met is first, the relationship of privity of interest. So a situation where an award awarded in respect of one of those entities directly affects the other. And this is exactly the case at hand, since Donald and Daisy are shareholders of claimant holding 75% of stake. And now the second prerequisite is the control over that company by shareholders. And members of the tribunal, in that respect, I would like to refer you to the case Supervision versus Costa Rica, where it was clearly stated that there exists a general presumption of control over the company when there is majority shareholding in that, a shareholder has majority shareholding in that company. And this is also exactly the case at hand. It is to be addressed also the fact that Donald and Daisy hold, one of them holds 30% stake and the other 45%. So each of them separately would be minority shareholder. However, as it was stated in, for instance, for von Petzold versus Zimbabwe case, even if there are multiple shareholders that act together, this shareholding should be taken into account together and constitutes controlling shareholding.
Counsel, isn't it a little bit unfair for the claimant that a few of its shareholders decided to pursue an arbitration for their own benefit? The claimant wasn't even aware of that previous arbitration, and now it is banned from pursuing and asking for compensation for its damages?
I understand your concern, Madam Arbitrator. And in that regard, actually, that brings me to second and third prong of the triple identity test, so subject matter and cause of action. Because what I believe Madam Arbitrator is asking for is the fact whether a situation where previous claimants would gain benefit for their own and company now is seeking compensation for its own. And this is exactly not the case at hand. Members of the tribunal, in order to address that, I would like to firstly refer you to page 33 of the record, which is Donald and Daisy case. Is the tribunal with me? Now, members of the tribunal, let us look at paragraph 10, second line. And I quote, "They are claiming for a so-called reflective shareholder loss on behalf of an enterprise, which is Sutton Investments, that they own or control directly or indirectly, which was subject to various attacks and lootings from 2014 onwards." Now, members of the tribunal, let us look at page 81 of the record. Which is the BIT itself. Article 20 of the BIT, awards and enforcement of awards. Paragraph 2 of this article states, and I quote, "Where a claim is submitted to arbitration for loss or damages to an enterprise," which is Sutton Investments, letter B, "an award of monetary damages and any applicable interest shall provide that the sum be paid to the enterprise," which is Sutton Investments. Members of the tribunal, does not matter whether the award is given to the previous claimants or to the one at hand. It always goes to the same entity, which is Sutton Investments. And this exactly is double recovery, or the so-called claim splitting, which was declared by the, for instance, Apotex Tribunal as unacceptable. Members of the tribunal, what Claimant is in fact doing here is trying to send the same gift, however, packing it in a different box. And this cannot be accepted.
But isn't it a materially different box? Because one of the claims is an expropriation claim, and this claim is a full protection and security claim. So even if we're with you on this point, and we regard the two claimants as being in privity of interest, how do you deal with the different cause of action point? I know you're coming to it, but I think it's perhaps the biggest point.
Absolutely, Mr. Arbitrator. Members of the tribunal, what should be taken into account here is the fact that the damage that was invoked by the previous claimants and the one at hand are the same. Let me explain that. What Claimant is seeking for here? Firstly, compensation for destruction of cannabis plants, and secondly, moral damages. Now, seeing that I have only 1 minute left, can I ask respectfully for only 1 minute to address this issue?
Yes, of course, yes.
Of course, members of the tribunal, let us look first at the destruction of plants. The value, the destruction of assets of the company translates into loss, diminution of value of this company, which later on ultimately leads to loss of value of the shares. Now, members of the tribunal, the loss of value of shares of previous claimant directly reflects the loss of value of the company caused to the destruction of assets. Now, addressing the second claim, members of the tribunal, moral harm, moral reputational harm done to a company is the same also as the previous one. So there are multiple factors that influence the value of shares, among of which is an image of a company in the eyes of investors. Any reputational harm done to a company also results in diminution of value of shares, since investors are simply unwilling to get involved in a questionable business. And therefore, the moral damage that is addressed here was already addressed in the diminution of value of shares. And moreover, as there are multiple factors that influence the diminution of value of shares, there were even more issues that were included in the previous award. And this should be taken into account, members of the tribunal.
Counsel, are you admitting that there was moral damage done to the claimants?
No, Madam Arbitrator. The respondent here addresses the not only hypothetical issue, but rather abstract issue of possible overlapping of claim one another. And this is the issue that happens in the case at hand.
But what is the specific issue that's been decided that you're saying can't be redecided?
Mr. Arbitrator, it is...
What is the race, the specific race that you're saying is judicata?
I'm not sure if I understand Mr. Arbitrator's question. Well, could I please...
Because you're saying you can't look at this issue again because it's already been decided in the D&D case. But that's a case that concerns expropriation. You answer that by saying, well, it all comes down to the same issue of loss. This is now before this tribunal. But where in the prior award do you say this issue has already been decided? You tribunal cannot look at it again. What is the specific issue?
So, members of the tribunal, this issue is that following the I understand that they have time for addressing Mr. Arbitrator's question, following the prerequisites of triple identity. So the issue that has already been decided is that in relation between claimant, so claimant's investment, Sutton Investments, and respondent, so Rhekia, identity of the parties, a harm that was done allegedly by respondent under the BIT, so the fact of destruction of cannabis plants of Sutton Investments, was contrary to the provisions of the BIT. This is the issue that has already been decided. Also, taking into consideration the fact that allegedly certain moral harm was done to Sutton Holdings or Sutton Investments, depending on what claimant is in fact stating here. And this, in fact, addresses all issues that would be raised by respondent in case of jurisdiction of this tribunal. Thank you very much.
Thank you very much. We're going to turn to the claimant, please.
Just once again to confirm, can you hear me?
Yes, we can. If we cannot, if we have trouble, I will let you know.
Thank you very much. Members of the tribunal, as was introduced, my name is Anna Gatkaluk, and in the following 90 minutes, I, on behalf of the claimant, will address the jurisdictional issues of the present dispute in the same order as the counsel for respondent did. And I will accordingly disapprove the arguments of my opposing counsel and state that the present tribunal, in fact, has jurisdiction over the present dispute, stating that first, the claimant is entitled to bypass the requirement enshrined under Article 12 of the BAT, and second, res judicata effect cannot be applied in the present case. Coming to the first argument presented by my opposing counsel, respondent stated that exhaustion of lawful remedies is mandatory jurisdictional requirement, and we did not dispute that exhaustion of lawful remedies is a mandatory one. However, members of the tribunal, claimant is entitled to bypass this requirement on the ground of futility exceptions enshrined under customary law. And before we move to this, we would like to pay the tribunal's attention to the paragraph 2 of Article 12 of the BAT, which states the scope of exhaustion of lawful remedies. And respondent alleged that exhaustion of lawful remedies under the BAT requires only to submit the dispute to the local court and wait for 18 months. However, such interpretation would make this requirement meaningless, as it will be a mere waiting period to which the parties did not agree. Alimony versus Argentinian Tribunal, analyzing the clause similar to the paragraph 2 of Article 12 of the present BAT, stated that such requirement cannot be regarded as just a mere formalistic step, but rather the party's intention was to give an opportunity to resolve the dispute on its own fora before the international responsibility occurs. And my opposing counsel agreed that the purpose of this requirement was to do so. Therefore, at least a final decision in the first instance shall be given by the claimant. And Rhekia courts manifestly failed with this exclusion. Members of the tribunal, the test which claimant would like to propose in the present case is the most balanced and fair one. In oral proceedings, my opposing counsel stated that we shall apply the approach of ICS versus Argentina. However, we would like to draw tribunal's attention to the fact that this case used the obvious futility threshold, which cannot be applied in the present case. As I previously mentioned, futility exception arise from customary law of diplomatic protection, which is relevant and applicable via treaty interpretation under Article 31(3)(c) of the Vienna Convention of the Law of the Treaties. And therefore, it states that the most balanced test of futility will be addressing the most reasonable available court or effective one. And obvious futility threshold cannot be applied in the present case, since it would require too harsh burden for the claimant to comply with and give so many benefits for the whole state. While the test proposed by the claimant is the fairest one, as it regards the both interests of the whole state and the party itself. And here I would like to draw tribunal's attention to the fact that Rhekia courts could not meet such threshold, as we were incapable to render any decision in the first instance within 18 months. And here we would like to invite the tribunal to the page 60 on the paragraphs 23 and 24 of the record. And there stated that complex commercial disputes, including investor-state disputes, led to the significant backlog to Rhekia in 2013. And this backlog persists till date. Members of the tribunal, this means that complex commercial disputes, including investor-state disputes, were so complex for Rhekian judicial system that it could not render any final decision for this period of time. My opposing counsel referred that Rhekian courts might have rendered a final decision in a period from 60 to 12 months. However, if you look at the page 65 of the record and exactly to the paragraph 49, the time period of 16 to 18 months was for the typical case to be heard. And this dispute, as investor state one, was obviously not the typical one. Turning to the period of 12 months, which occurred by 2021, members of the tribunal, it included an expedited procedure which shareholders used. And for this reason, respondent who referred to the shareholders' exhaustion of local remedies actions cannot satisfy this requirement, as well as the use an expedited procedure which cannot be applied in investor-state disputes for the following reasons. First, Advisor versus Argentina Tribunal recognized that investor-state disputes are most complicated ones, and they include the analysis of the majority of facts and arguments, while expedited procedure limited its analysis and therefore precluded the effectiveness of the resolving of the dispute. And the second point, even if the tribunal stated it might be effective for the Daisy and Donald, however, in the present case includes much more issues that needs to be resolved. It includes not only the violation of the full protection and security standard, but also the war losses clause, as well as the awarding of moral damages. Therefore, members of the tribunal, Rhekian courts would have to resolve much more complicated issues than in Daisy and Donald case. And that is why they would have manifestly failed to render the decision in the following 18 months. And we would like—
Counsel, I'm sorry to interrupt you. I have a question in my mind, and I wonder if you can help me. I understand what you're telling us about futility. I have certain issues with the fact that we're being asked to pass judgment on a state court system's ability to look at certain cases, never mind complicated cases. But let's put that aside for one moment. Why is it that the claimant never even took the first step towards starting a claim in the courts to at least show willing? Because at the moment we have absolutely nothing on your side that even goes in the direction of local remedies. Can you help me with that?
Indeed, Madam President, claimant did nothing, not in a bad faith, but rather that because claimant had grounds not to file the claim to the local courts as they were futile. However, members of the tribunal, claimant complied with the requirements enshrined under Article 12, for instance, under paragraph 4 of the Article 12. And therefore, if the Rhekian courts would not have been futile, a claimant would definitely fill the claim to the local courts. However, claimant has the grounds not to do so, as there was the only a formalistic step that as no decision could have been rendered in such period of time.
Counsel, why is it relevant? Sorry. Why should we consider whether a decision could or could not be rendered in this time period when the wording of our BIT does not require a decision, but only that time period to elapse?
Madam Arbitrator, we cannot directly interpret this wording as only an obligation to submit the dispute to the local court. As in this sense, as the way what was proposed by the opposing counsel, it would mere a formalistic step and just a waiting period. However, the present case requires the submission of the dispute to the local court. And as the purpose to resolve the dispute before the international responsibility occurs, we should, the courts should have a capability to render the decision in such period of time. Otherwise, it would be just, it would be a mere formalistic step and a waiting period to which the parties are not agreed. And we would like to draw the tribunal's attention to the fact that a waiting period requirement has already settled in this BIT under paragraph 4 of the Article 12. For these reasons, at least final decision in the first instance, the claimant, the Rhekia courts should render.
Can I ask two questions? Why can't the treaty parties agree to what you describe as a merely formalistic step? If they want to have recourse to their domestic courts, even though that's positively unlikely to lead to a determination within 18 months, why can't they agree to that? And second question is, what effect do we give to Article 12.3? How does this fit within your argument?
Mr. Arbitrator, I'm not sure I catch your second question.
Second question is how does compliance with Article 12.3 or non-compliance, how does that fit within your argument?
Indeed. Answering to your first question, Mr. Arbitrator, the parties cannot agree to include formalistic steps in the BAT as each article in the BAT requires a certain agreement between the parties, and the requirement of exhaustion of local remedy serves the very simple purpose, is to prevent occurrence of international responsibility and to try to resolve the dispute on the domestic level. And if the courts are not capable to render any decision within the stipulated time frame, the investor will definitely go to the international tribunal to resolve the dispute. That is why the inclusion of such provision would be meaningless for the parties, as the dispute would not be resolved. Coming to your second question, Mr. Arbitrator, the claimant's position here that the non-compliance with exhaustion of local remedies requirement does not has the grounds as first to the futility, and second that actually it is not a jurisdictional issue but an issue of admissibility, as if you have a look at the Article 14 of the present BAT, it provides that each party gives unconditional consent to the submission of the dispute to international arbitration, which means that the parties intentionally separated first article about the consent to the arbitration and second about the procedural steps to implement the consent that has been already given by the host state at the moment of the BAT entry into force. Therefore, as Rhekia courts were futile, claimant respectfully asked the tribunal to decline the first jurisdictional objection of the respondent. Coming to the second.
I'm sorry, I just wanted to bounce back on my co-arbitrator's question about 12.3, because I don't think you've addressed us on the meaning of the condition precedent. We understand that there has been an unconditional, well, there is a condition here. That's the problem. 12.3 so there is clearly a mismatch between what you've just said and what we're reading in 12.3. Is there any treaty interpretation provision that we should take into account in looking at this disparity?
Indeed, Madam President, we invite the tribunal to the Article 31 of the Vienna Convention of the Law of the Treaties, which means that the treaty shall be interpreted in good faith. And as you clearly mentioned that we have a contradiction between those two provisions. On the one hand, we have unconditional consent, and in the other article of the BAT, it is conditioned. And it is clear in contradiction, and claimants invite the tribunal to follow the approach of Ichkal versus Turkmenistan tribunal, which stated that if they have such contradiction between those two articles, the conditions implemented in the BAT shall be regarded as the procedural steps to implement the consent, which has been already given by the host state, but not affect the existence of such consent. Therefore, we submit that it is an issue of admissibility, but we still agree that it is mandatory to apply. However, the claimant is entitled to bypass this requirement due to the futileness of the Rhekia courts. Coming to the second respondent's objections to jurisdiction, which is res judicata, we agree with the test proposed by my opposing counsel that it is triple identity test. However, we disagree with the outcome of application of this test, and we would like to draw the tribunal's attention to the fact that this test is cumulative, and the failure to comply with at least one criterion would make res judicata inapplicable in the present case. Coming to the first criterion presented by the respondent, which is the parties, respondent stated that the economic interests of the shareholders and the company itself are equal, and therefore the parties shall be considered the same. However, members of the tribunal, the circumstances of the present case clearly show that the company's interest and the interest of shareholders were clearly distinct. And we would like to invite the tribunal to the page 90 of the record, and particularly to the paragraph 16, where stated that Daisy and Donald initiated a claim for their shares alone and did not communicate or consult with Sutton Investments and of the court, which means that the claimant was not even aware about the initiation of claim of the shareholders. They acted only in their sole purpose to recover their own losses. Moreover, members of the tribunal, after shareholders lost in all counts, both in the domestic proceedings and in the international courts, they decided not to invest any more time or money to the situation occurred at Rhekia. Therefore, they did not even join the proceedings, and that is why the company itself and the shareholders are not economically connected in this thing, as the compensation in the first case would be granted solely to shareholders. And that leads me to the second criterion of res judicata proposed by my opposing counsel, which is subject matter. Respondent stated that under Article 12.2 of the BAT, the compensation would be granted to the Sutton Investment. However, members of the tribunal, we would like to invite you to the treaty interpretation, and it clearly stated that the compensation would be granted to the company if a claim is submitted for the loss or damages to an enterprise, as the wording of BAT is quite clear. And Daisy and Donald submitted their claim for their own losses, reflective losses as shareholders. And they submitted their claim for the diminution of the shares. And these losses are particularly distinct from the losses, direct losses the company might suffer. And as you can clearly see from the Daisy and Donald award, which stated on the page 34, and particularly under paragraph 15 and 16, it is on the top of the page. The Daisy and Donald Tribunal gives particular attention, and I quote, that particular market has to be considered and given considerable weight, end of the quote, which means that by analyzing the scope of damages presented by shareholders, the Daisy and Donald Tribunal paid particular attention to the market where the shares is allocated and which reflected on the diminution of the shares. Despite the mere connection between the direct losses of the company and the shares, there are so many factors that influence the price of the shares, and therefore we cannot submit that subject matter in both proceedings were the same, and ask the tribunal to decide that the subject matter was different. Coming to the third criterion presented by my opposing counsel, which is cause of action, my opposing counsel stated that there are the same damages occurred. Therefore, the cause of action is identical. However, members of the tribunal, claimant has already demonstrated that the scope of damages are quite distinct. As the previous is in first proceedings, there was the diminution of the shares which suffered, and in the present case, the claimant seeking compensation for the destruction of the prayer and audience. And here we would like to note that in the present case, the claimant is seeking the compensation for the breach of full protection and security standard, while in the previous one it was for indirect expropriation, which means that there is a distinct scope of legal protection required under these two legal standards. For instance, full protection and security standards gives a protection for the investor's assets of the third party's actions not attributable to a host state, whereas indirect expropriation only covers the actions of the party of the host state. Therefore, none of the criteria of res judicata is satisfied, and the jurisdiction of the present tribunal shall be. Therefore, we ask the tribunal to decline all the respondents' objections to jurisdiction. Thank you.
Any more questions from us on this?
Not from my
No?
side.
No. Thank you very much. We have a rebuttal from the respondents, please.
Members of the tribunal, in the rebuttal, I would like to point out two things. First one, the claimant relies in its argument concerning the exhaustion of local remedies, all argumentation, on the fact that 12 months period of average time in 2021 to resolve a dispute was such a short only due to inclusion of expedited procedure. However, it omitted the fact that the previous 16 to 18 months also included the expedited procedures. Members of the tribunal, Donald and Daisy was resolved in 2016 in expedited procedure. So this is completely misplaced argument. Concerning the second point, Donald and Daisy stopped engagement in the business after the proceedings. Well, that is true, members of the tribunal. However, according to Aguas del Tunari versus Bolivia case, tribunal stated that no active involvement is necessary in case of majority shareholding to hold control and thus declare identity of the parties. Thank you.
Thank you very much. I believe your opponents addressed a question that my co-arbitrator, Mr. Wordsworth, put to you earlier, which is the different nature of the remedies. And they explained that in an expropriation case, obviously, the lesser value of the shares that result is the indirect impact of the expropriation. Whereas in the full protection and security claim that we have before us, we have, the actual damage caused by what happened. And are you able to rebut on that at all?
Of course, shall I have...
You have 1 minute.
1 minute, of course. Madam Arbitrator, in two points. First one, as I elaborated on before, in fact, the same damage caused to assets and later on to reputation is reflected also in the lesser value of the shares.
I understand that, but that's
Yeah.
a second hand, that's a sort of ricochet, as we might say. The immediate damage that is being claimed is different.
Yes, Madam Arbitrator, to a certain, that could be a parent view. However, this is exactly what claim splitting is, what was declared by Apotex versus USA case. So a situation where the same damage is packed in a different box. So a situation where the relief sought is the same, or even the relief sought is a bit different. However, so there is a little bit different relief sought or the same relief sought, but a different provision from the treaty is taken into account. And this is exactly claim splitting that was declared by Apotex tribunal as unacceptable. So this is exactly, that should not be accepted also by this tribunal.
Thank you very much for answering this. Thank you. So rebuttal on the claimant side?
Madam Arbitrator, let me please clarify for what part of the rebuttal I shall refute, like the first part of after the question.
Sorry, I missed that. I'm sorry, I missed what you said. Please say again.
Please let me clarify on what part of rebuttal of my opposing counsel I shall refute, because he used his choice twice, once for your question and before.
Well, you have the time that you have, so please use it as you wish. And if we have more questions, then I'll give you an additional minute.
Thank you, now I understand. Sorry. The respondent stated that expedited procedure was implemented in the time of 16 to 18 months was required to implement the dispute. However, members of the tribunal, expedited procedure was implemented after the civil conflict, which ended in April 2017, while the time allocation from 16 to 18 months is relevant only for the early 2017, which is the March, according to the statement of uncontested facts. Therefore, since Rhekia courts could not resolve the dispute within 18 months due to the complexity of it, the respondent cannot condemn that they were not futile. Going to the second respondent allegation, we submit that that is not only the joining the procedure was the main feature of why the parties are different, but rather the fact that the interests were distinct and the interest of shareholders in the previous case was to recover their own losses, not the losses on the company, not in the interest of the company. Therefore, the tribunal has jurisdiction. Thank you.
Thank you very much. We are moving on to the merits, and then we're going to start with the claimant, please.
Honorable Tribunal, esteemed opposing counsel, as was introduced, my name is Elizaveta Artsakova.
and I will be presenting the merits of the dispute on behalf of Claimant. In the following 19 minutes, Claimant will demonstrate that first, Respondent breached the full protection and security standard within Article 5 of the BIT. Second, compensation for this breach is not precluded by Wallace's clauses in Article 6, contrary to Respondent's allegations. Third, Claimant is entitled for Wallace's suffrage of order in accordance with Article 6.2 of the BIT. And finally, compensation for moral damages shall be paid. Starting with the first Claimant submission on the violation of the full protection and security standard, Claimant submits that Respondent failed to exercise due diligence and accord full protection and security to Claimant's cannabis plants, prayer, and order during the civil war in Rhekia. Claimant submits that first, Respondent failed to prevent the attacks on prayer and order, and second, Respondent destroyed order with its own military forces in violation of the full protection and security FPS standard and may not refer to the state of necessity to escape liability. The full protection and security standard requires from the whole state to exercise due diligence, which requires from the state to provide protection against third-party actions and interference of the state reasonable under circumstances. However, Respondent failed to act diligently and prevent the attacks on prayer and order. Respondent may allege that these attacks were not foreseeable and thus they could not have been prevented. However, Claimant submits that these attacks were foreseeable for the following reasons. At the time of the attacks, Rhekia was in a state of the civil war, which occurred on the discrepancies within Rhekian society on the issue of cannabis legalization, and Claimant was the biggest cannabis investor in Rhekia. Even more so, Claimant started asking for assistance since the beginning of the war in 2014 and until the first attacks on Claimant's cannabis plants started in 2016. However, Respondent ignored all these requests, and in the words of the Rhekian Deputy Minister for Home Affairs, witnessed by Claimant's CEO, Respondent decided to prioritize other investors. Consequently, Respondents should have been aware that Claimant's cannabis plants would be targets for militia groups. In light of that, Claimant submits that Respondents should have taken certain measures in advance to prevent the attacks on prayer and order. Respondent could have deployed forces nearby the plants after the Claimant's requests for assistance in order to shorten the time required for forces to reach the plants given their remote location. However, Respondent did nothing to prevent the attacks and failed to act diligently, and that is why there is a breach of the full protection and security standard. Second, Respondent breached the full protection and security standard as it destroyed order with its own military forces. Respondent made two attempts to destroy order. First, it razed buildings located on the outskirts of Odin, and second, it destroyed Odin's agricultural buildings. To justify the destruction of Odin, Respondent may rely on the customary standard of necessity codified in Article 25 of Articles on the State Responsibility. This article provides that a plea of necessity is available for the state if its act was the only way for the state to safeguard an essential interest against grave and imminent peril. In regard of the first instance of destruction, Claimant submits that this destruction was not necessary. The International Court of Justice has stated in Gabchikova-Nagimarosh case that a peril shall be established at the relevant period of time. However, in the present case, at the time of the destruction of Odin, occupation of some buildings on the outskirts of the plant was not a grave and imminent peril which required destruction of them by the military. Moreover, after the destruction, militia groups were able to continue the attack for 2 months. Furthermore, it was not the only way for Respondent to safeguard its essential interest, since its most effective troops could have continued to resist militia, considering since they suffered from a lack of food and supplies, and prevent the occupation of the eventually razed buildings. Regarding the second instance of the destruction of agricultural buildings, claimant submits that, similar to the first destruction, they were destroyed unnecessarily. First, there was no grave and imminent peril, which required destruction of these buildings. It would be meaningless for militia to grow food there. And moreover, since people can live without food approximately 7 or 10 days, militia would have left Odin to find some food before they could even utilize the agricultural buildings. And second, respondent had alternatives to safeguard its interests, such as use of airlift for delivering food for soldiers to continue the resistance. To conclude my first argument, the tribunal shall find the violation of the full protection and security standard, as respondent destroyed Odin unnecessarily with its own military forces and failed to prevent the attacks on Freya and Odin. The second claim submission on Warlaw's clauses in Article 6 of the VAT will consist of 2 points. First, Article 6 does not preclude the obligation to provide FPS standard and compensation for its breach. And second, claimant is entitled to compensation for war losses suffered at Odin due to the destruction of the plant by the military forces in accordance with Article 6.2. We invite the members of the tribunal to open the record at page 75, where Article 6 of the VAT is presented. Is the tribunal with me?
Yes.
This article consists of 2 clauses. A war clause in Article 6.1 provides for an obligation to provide most favored nation treatment and national treatment to foreign investors in relation to compensation for war losses caused at war. A war clause in Article 6.2 provides for a standalone obligation to compensate for losses resulting from the destruction or requisitioning by the host state. Claimant is invited the tribunal to find that both war clauses in Article 6 of the VAT do not preclude the obligation to provide FPS standard and compensation for its breach. Claimant is aware of approach to which respondent may refer the tribunal that Wallace's clause are sometimes considered as precluding the FPS standard. However, such interpretation requires a particular wording of the VAT. For example, in Plessy versus Algeria, the tribunal referred to the wording of the VAT of the Wallace's clause, which requires treatment during the civil war in general, whereas in the present case, a war clause, the present VAT, limits treatment to restitution, indemnification, compensation, and other settlement. Moreover, numerous investment tribunals such as Cengiz versus Libya, Gurus versus Syria, and Total versus Argentina disregarded the lex specialis nature of said provisions and noted that Wallace's clause provides for an additional guarantee of equal treatment in respect of war losses. As to Article 6.2, it does not override the obligation to provide FPS standard and compensation for its breach. Subject matters of Article 5 and Article 6.2 are different. Article 5, which provides the obligation to provide full protection and security standard, is a provision of property protection, whereas Article 5 of the VAT is provision of compensation for destruction or requisitioning of investor's property by the host state. Moreover,
Can I just interrupt you by asking a question? Article 6.1 is a form of non-discrimination provision. Would you agree with that?
Indeed, Mr. Arbitrator.
So if one then looks at Article 3, Article 3.1, again, that's a form of non-discrimination provision. So doesn't the fact that you have a non-discrimination provision which deals with specifically this small subcategory of losses due to war, armed conflict, and the rest, doesn't that imply that when you have that specific condition, you should just be looking at Article 6. Otherwise, Article 6 doesn't really serve any purpose, does it? Because you already have the non-discrimination obligation as regards national treatment in Article 3 and as regards most favoured nation treatment within Article 4.
Mr. Arbitrator, as was mentioned in Gurus versus Syria, case, a provision of most favored nation treatment and national treatment is a lex specialis to all losses clauses similar to Article 6 of the BAT. Article 6.1 of the BAT provides for the obligation of most favored nation treatment and national treatment in relation to compensation for losses suffered at war. So, Article 6.1 is a special rule in the context of the civil war, as we have in this case. And proceeding with the second part of the second submission, conditions of Article 6.2 are satisfied, and therefore compensation for the destruction of Odin is due. Article 6.2 provides that the state shall compensate losses resulting from the destruction of investments by the state unless at least one of two exceptions is presented. First, the investment was destroyed in combat action, or second, its destruction was necessary. However, Claimant submits that in the present case, Odin was destroyed in not combat action. Black's Law Dictionary defines combat as a forcible encounter between two persons, or adapting this definition to the state of war between two parties of the conflict. However, in the present case, there was tactical decisions of the state to destroy Odin facilities, and therefore Respondent decided to raise the buildings at Odin not during the fight with militia. Therefore, since the requirement is not satisfied, Odin was not destroyed in combat action. Regarding the existence of the war, existence of the necessity, as was demonstrated previously in the submission on the violation of the full protection and security standard, the destruction of Odin was unnecessary, as there was no great and imminent peril which required from the state to destroy Odin facilities, and it was not the only means to safeguard Respondent's interest. To conclude, the second submission, both war clauses in Article 6 of the BAT do not preclude Claimant from receiving compensation for the violation of the full protection and security standard, and Claimant is entitled to compensation for war losses suffered due to destruction of Odin's facilities in accordance with Article 6.2. Moving further to the last submission, Claimant is entitled to...
Counsel, sorry. Before you move to your following submission, going back to the FPS and the war clauses, when analyzing the necessity requirement, shouldn't this tribunal also consider what happened after Odin was exploded? I mean, we know now that we have the full picture that after that, the war came to an end a few months after. So should we take that fact into account when analyzing if the measure was necessary or not?
Excuse me, Madam Arbitrator, could you please clarify the question?
Yes, sorry. Are you hearing me correctly?
Yes, no.
My question was, when analyzing the necessity requirement, whether when we consider if the explosion of the plant in Odin was necessary or not regarding the whole context of the war, should we give some weight to the fact that after the bombing happened, we know a few months afterwards, the war came to an end? So what I mean is, although we may not have known that at the moment, we know that now. So shouldn't we take that fact into account when analyzing if the measure was necessary or not?
Madam Arbitrator, the fact that the militia's advance became slower after the explosion of some Odin's facilities should not be taken into account, since the fact was that militia groups continue their further advance and eventually reached other buildings of Odin. And moving further to the third conviction, Claimant is entitled to moral damages
as the requirements for their award are fulfilled and they are not prohibited by the present VAT. Respondents' inaction against in relation to claimant's cannabis plans linked to numerous allegations of respondent that claimant took part in funding the militia groups during the Civil War. And eventually, there was an announcement of investigation against claimant. Therefore, there was a violation of the legal security requirement within the FDI standard, and for that, respondent claims moral damages. Respondent shall compensate moral damages since there is a proximate causal link between respondent's announcement of investigation, which breached legal investment environment of claimant, and claimant's reputational harm. A fresh equity offer was undersubscribed, and the denial of loan was occurred. And it occurred in a short period of time after the announcement of investigation. More specifically, it happened in next month. Thus, the respondent's announcement of investigation against claimant was the most proximate causal link to its reputation, and thus moral damages shall be compensated. Additionally, we invite the tribunal to find, contrary to respondent's allegation, that moral damages have compensatory but not punitive nature, as was held in the Lusitania cases. Thus, in the present case, moral damages are not prohibited by the VAT. To conclude our submissions, respondent...
Just before you conclude, I'm sorry to interrupt. Remind me how much you're claiming for moral damages, please.
Madam Arbitrator, we are claiming $10 million for moral damages.
How do you come to that sum?
Madam Arbitrator,
I just struggle. The reason I'm not trying to be facetious, I just struggle a little bit with the amount and how we can, as a tribunal, probe the adequacy of that amount, given that we are talking about a non-tangible loss that you are claiming. Other jurisdictions would allow, if they found moral damages to be appropriate, would find a token amount. The idea, the important thing being the finding as opposed to the amount of money. So if you are able to persuade us that this 10 million is adequate, what are the bases for the amount of money that you claim?
Madam Arbitrator, $10 million is enough for moral damages since there was a breach of legal security within the FDI standard, which is separate ground for compensation. And that is why I would like to refer the tribunal to page 6 of the record. Paragraph 24. I quote, according to the Sutton's quantum expert's calculation, Sutton losses for the moral damages are estimated to be at least $10 million. So the tribunal shall decide it in discretionary manner what amount of moral damages will be compensated. However, the tribunal shall bear in mind that Sutton's quantum experts calculated the moral damages in sum $10 million, and we claim moral damages for respondent's announcement of investigation, which breached investment environment of the claimant and harm to its reputation. And that concludes my submissions. Thank you.
Are you able to point me to any cases where moral damages have been awarded in that magnitude of money so that we can make a comparison, please? That similar amounts of money awarded for moral damages in other cases where we could perhaps look at the reasoning and draw inspiration.
Indeed, Madam Arbitrator, for instance, in Desert Line, moral damages were awarded, and that is why the moral damages shall be awarded in the present case. However, with the exact amount of moral damages that was awarded in that case, we will provide the tribunal with such information in our post-hearing brief.
Thank you. Are you done with your submissions on the merit? Yes. Thank you very much. Respondent.
Honorable members of the tribunal, good afternoon. As already introduced, my name is Lucia Vilaseca, and on behalf of Respondent, the Republic of Rhekia, I will now address the merits of the present dispute. But before I make my submissions, members of the tribunal, I will ask you to keep one thing in mind, which is that all the actions spoken of today were happening during a civil war. Now, members of the tribunal, to quote Claimant's own exhibit, at that time, cities were burning, buildings were pillaged, and the body count was growing. And in times like this, the objective and perspective must change. The main objective of everyone involved, the citizens and the investors alike, is not just profit-making anymore, but it becomes protecting the lives and safety of both the citizens and the investors by the state.
Can I just ask, what's the treaty basis for that submission? Because that sounds like a very attractive submission from a common sense point of view. There are various clauses within the treaty that deal with exceptional situations, and surely we shouldn't be looking beyond the application of those individual provisions, save for applicable customary international law rules like Article 25.
Mr. Arbitrator, that was stated in multiple cases that also dealt with the question of FPS standard enshrined in our BIT in times of civil conflict. For instance, in the case Ostis versus Libya, the tribunal has found that civil war constitutes such an extraordinary circumstance that it changes the obligation incumbent on the state. Now, members of the tribunal, that is why we ask you today to contextualize all the submissions made by the parties in the light of this civil war of unprecedented magnitude. Because we submit that only keeping in mind the reality of that war can we truly assess the obligations of the parties. And with that, we will be making three submissions. First, that Respondent has upheld its obligation to provide full protection and security to claimant, which I will refer to as the FPS. Secondly, that the war losses clause precludes the compensation being awarded to claimant unless certain other prerequisites in that clause are met. And thirdly, that claimant is not entitled to compensation for moral damages. And for the tribunal's convenience, I will be mirroring my opposing counsel structure. Now, members of the tribunal, starting with the first submission, that Respondent has upheld its obligation to provide full protection and security. We concur with the standard of liability adopted by my opposing counsel, which is one of due diligence. However, members of the tribunal, my opposing counsel has defined the obligation stemming from that standard as to provide protection, simply. There lacked a legal basis for that claim. Therefore, I will provide alternative understanding of that obligation of due diligence adopted by numerous tribunals in similar circumstances, and the obligation on the state is to take reasonable measures to protect claimant's investment. Now, members of the tribunal, quoting my opposing counsel, Respondent could have deployed military forces nearby. Members of the tribunal, that is exactly what the Respondent did. Because as I will demonstrate, Respondent not only deployed its forces preemptively, but also reacted swiftly to the danger occurring at the plants. And to demonstrate that, if I may invite members of the tribunal to page 64 of the record, that should be page 67 of the PDF. Are the members of the tribunal with me? If I may quote members of the tribunal, third line of that paragraph, Odin, which is claimant's second investment, was located in an area where the authority of the Rhekian state was weaker than in the urban centers, and large number of anti-government protests had occurred prior to the official outbreak of the civil war, Because of this, Rhekia posted a large number of its most effective troops to that region, and therefore members of the tribunal, even adopting my opposing counsel's definition of the FPS, the Respondent did exactly that. It deployed military forces nearby the plant. But Respondent did not only that. That was not the only measure taken. Secondly, members of the tribunal, when the damage occurred and both plants were attacked, firstly, in regards to the first plant, Freya, Respondent deployed a few military units within only 48 hours. Now, members of the tribunal, one might ask a question whether that is a reasonable time to respond, and especially raising the argument advanced by my opposing counsel as to whether the attack was foreseeable. Well, a similar issue has been dealt by tribunals in, for instance, ample American case, in which there were also attacks on claimant's property. And in that case, members of the tribunal has found that the state had 6 months to protect the claimant's investment from the first attack occurring. 6 months. And in that case, members of the tribunal, there were numerous attacks, and the state disregarded the first all 14. And the tribunal has said, first 4 attacks are unforeseeable. And members of the tribunal, in the case at hand, there was military deployed preemptively, then there was 1 attack, and to both plans, troops were sent after this first attack. To one within 48 hours, but the troops unfortunately were not able to salvage that plan. And to the other one, if I may take the tribunal now to page 93 of the record, paragraph 8. That is the second plant after the first attack. Rhekia sent soldiers to Odin after it was initially ransacked by rebels. Second line, Rhekian soldiers were preparing to defend Odin before it was attacked again on August 27, 2016. And therefore, members of the tribunal, we do submit that respondent did take reasonable actions, and especially to emphasize the context of the civil war, may I just mention that at the same time as those attacks took place, 2 of the main cities of respondent were taken over by armed militia. And even with that, even having to restore its power in the 2 main cities, it still managed to deploy troops to not just one plant, but to both of them. And therefore, members of the tribunal, we submit that the threshold under the FPS standard is indeed met.
Counsel, could you clarify when did the war start?
Of course, Madam Arbitrator. First violent protests occurred in 2014, and then in March 2015, the civil war broke out.
Okay, then, although we have 48 hours since the attack, we have more than a year since the war began and the state of Rhekia sent troops to the plants. So shouldn't we consider not only those 48 hours, but also the entire year and a bit more that had been occurring?
Of course, Madam Arbitrator, we should take all the circumstances into account. But if I may just stress that the civil war was not just centering around the cannabis industry, because the initial protests that were centering around controversial cannabis industry, they revealed some deeper division in the society, which is stated in the uncontested facts as well. And so the civil war that broke out was bigger than the cannabis industry. That's why the most of the violence was occurring in the cities. In the cities, there are no plantations of cannabis, Madam Arbitrator. And that is why we submit that it is impossible to defend everyone by sending troops to every single piece of property that may be in danger. It is simply impossible for a state with limited resources. And that's why we have to look at what the state could have done and what it did. And we submit that those measures are in fact reasonable. And now, members of the tribunal, moving to the second submission, which is that the war losses clause precludes this tribunal from awarding compensation to claimant, should it find a breach of the full protection and security standard, unless certain prerequisites are met. And if I may invite this tribunal to page 75 of the record, we will find a war losses clause there. Members of the tribunal, as you see, there are 2 clauses in Article 6. One is a sort of most favored nation clause that is found often in other BITs. But the second one, members of the tribunal, is quite rare. It constitutes a, so to speak, extended war losses clause. Now, members of the tribunal, my opposing counsel has stated that the Article 6 cannot exclude Article 5, and it has relied on cases such as Cengiz versus Libya, Total versus Argentina. But I stress one significant difference. In those cases, the war losses clause contained only the paragraph 1. It was not an extended war losses clause. And why is that significant? It's significant because we would concur paragraph 1 would not exclude compensation for the FPS. If the war losses clause contained only paragraph 1, it would not have exclusionary effect. However, members of the tribunal, paragraph 2 constitutes a substantive obligation on the state to compensate. And when does it need to compensate? It needs to compensate when the forces of the state either requisitioned the property of the investor, or they destroyed the investor's property out of combat or without unnecessarily. And therefore, members of the tribunal, effectively, this clause 6.2 overlaps with and has the same scope of application, just stricter and narrower than the FPS sought by claimant. The example of which is claimant's claim, which falls under both. And why are we asking this tribunal to find that Article 6 creates additional prerequisites for compensation for the breach of Article 5? Well, that was elaborated in the case of Ostas versus Libya, which we would ask this tribunal to adopt similar reasoning. The tribunal there found that civil war constitutes such extraordinary circumstances that, as I was mentioning before to Mr. Arbitrator's question, it can alter the obligations of the state in question. Because members of the tribunal, the state which is affected by such circumstances then needs its resources to be able to rebuild. And that's why it's reasonable for the state to want to limit its exposure to liability in such extraordinary circumstances as times of the war. And let me just emphasize that this clause, even with its exclusionary meaning, would not deprive investors of compensation if states act unnecessarily or requisition the property or act out of combat. So if states do act wrongfully, the investors will still be compensated. It's just in times of war, those three conditions, one of them must be met. And in the case at hand, members of the tribunal, those conditions were not met. And my opposing counsel has invoked two reasons, both reasons that the actions taken by the respondent were out of combat. And my opposing counsel has enacted definition that combat constitutes a possible encounter of the two sides. We adopt a similar definition, and if we may demonstrate using claimant's own words that there was effectively a combat. And if I may invite the tribunal to page 4 of the record, which is the request for arbitration. Paragraph 16, last paragraph. Members of the tribunal, I quote, claimant's request for arbitration. Eventually, when Odin was overrun by militia groups, Rhekian troops decided to detonate explosives. Claimant is now saying that the armed militia was not even there, but in request for arbitration, it has stated that militia, the Odin, the plant was overrun by militia. And we said that is precisely what happened. And addressing the second issue of necessity, my opposing counsel has invoked the standard for necessity under Article 25 of ILC articles. However, members of the tribunal, the standard that we should adopt in the case at hand is one of military necessity. And the prerequisites are quite similar to the one under ILC articles, except for one key significant difference. The standard under military necessity does not require the state to adopt the only measure. There can be other measures possible, but the requirements under the standard of military necessity are three. The measure needs to be taken for a specific military purpose. It must be required to reach this military purpose, and the military purpose must be legitimate. And we submit, members of the tribunal, that in the case at hand, those three prerequisites are met. Because what was really the objective of exploding claimant's plant? It is true, it would be capable of food production with some adjustments. But members of the tribunal, war is not just about food. As emphasized by various commentators to the current conflict of Russian invasion in Ukraine, the success in war depends on two things: morale and supplies. Odin facility was absolutely crucial in determining both, because at that point in time, both sides, the military and the armed rebels, were suffering because of lack of resources. So now control over this strategic object would determine whether then armed rebels enter into armistice talks or not. And here addressing the question raised by Madam Arbitrator, whether we should take the result of this action into account. And members of the tribunal, we submit that we should, because the result of the destruction of Odin plant was that both sides were struggling with supplies to such a degree that they entered into armistice talks. And we submit that had one side, the armed militia, dispose of this precious property, they would not have entered into armistice talks, and the war would not have been over, especially not at such an early point in time. And now, members of the tribunal, having addressed all the points.
Can I ask you a question on the merits? You're saying Article 6 establishes an exclusive regime that applies in the civil war and excludes the FPS provision. And you're relying on the Libyan case as support for that interpretive approach. I'm just wondering, was there an equivalent in the Libyan case to Article 28, the security and national interests provision?
Well,
which is on page 83 of the brief, because it could be said that that provides the relevant regime for what happens in the case of a civil war. You just apply Article 6 alongside Article 28, and either it's precluded because the action was required for the protection of essential security interests, or it's not.
Well, Mr. Arbitrator, firstly, we submit that the war losses clause, to clarify, war losses clause does not exclude the FPS itself, but creates certain additional prerequisites for the compensation to be awarded, just to clarify. And secondly, members of the tribunal, the war losses clause and security, essential security interest clause do not overlap completely. They overlap to some extent, but however, war losses clause is more specific, as the Article 28 applies in all times, and war losses clause applies in the certain prerequisites mentioned. And now, members of the tribunal, for the sake of time, I will move to the third issue of moral damages, where we submit that claimants are not entitled to claim compensation for moral damages. And now, members of the tribunal, let me point to a simple fact. There is no causal link between the breach alleged by my opposing counsel in the first part of her submission, the FPS and destruction of Odin, and then the compensation sought under moral damages. My opposing counsel has added in a second base, extending the FPS to provide legal security. However, members of the tribunal, there is no authority for requiring a state to provide legal security in times of civil war. Because members of the tribunal, we submit that such an extension of the FPS in times of war is simply unwarranted, as it could create an absolute and impossible obligation on the state. But addressing the second issue, members of the tribunal, the test that the tribunal should apply in determining whether moral damages should be awarded or not is to be found in the case Lemire versus Ukraine, which emphasized three conditions that were later adopted in other cases. And those conditions are cumulative. There must be a grave act contravening the norms of the civilized nations. There must be a grave moral damage and the substantive link. And claimant, the burden of proof, members of the tribunal, is on claimant, and claimant failed to substantiate and demonstrate any of those conditions, because simply publishing the criminal investigation being initiated is not a grave act contravening the norms of the civilized nations, members of the tribunal. And secondly, if I may just point to the fact that essentially what claimant is requiring the compensation for is the lost fresh equity offer and bank loan being refused. But those are, again, sources to rebuild his investment, but it's already asking for material damages to rebuild his investment. So this is not even a moral damage. It's a material damage, just repackaged again. And now, members of the tribunal, lastly, addressing the question of Madam Presiding Arbitrator as to the height of the moral damages sought. The case on which claimant relied was Desert Line, in which the employees of Desert Line were arrested and held by the state. Nothing like this happened in the case at hand, or at least claimant has not produced any evidence to state that the employees were at the time. And in the Desert Line, with those circumstances, moral damages of 1 million were awarded, whereas claimant in the present proceedings is seeking 10 million. And now, members of the tribunal, we re-emphasize that since there has been no breach of the BIT, claimant is not entitled to seek compensation under Article 5, 6, or moral damages. Thank you.
Thank you very much. Can we have rebuttal, please?
Thank you, the members of the tribunal. Contrary to respondents' allegations on the justification of destruction of ordnance buildings with the concept of military necessity, one of the cumulative requirements for invoke the state of military necessity is the military advantage brought to the state from this destruction. However, the first destruction of the buildings, which were located on the outskirts of Odin, did not bring military advantage to the state, as this destruction did not stop further malicious advance, and eventually militia groups reached the center of Odin. Second, the destruction of agricultural buildings did not bring a military advantage either. Growing food requires a considerable time. However, by the time when respondent raised agricultural buildings, militia had been already suffering from a lack of food, since their attack lasted approximately 2 months. Consequently, use of the raised buildings for growing food would be senseless for militia groups, and thus this destruction brought no military advantage to the state, and ordnance buildings were destroyed unnecessarily. And the second point for rebuttal is moral damages. For instance, in Al-Kharafi versus Indonesia, the tribunal awarded $30 million for moral damages, and it concludes my submissions. Thank you.
Thank you very much. Any rebuttal from you?
Of course, Madam Presiding Arbitrator. Addressing the first point of the rebuttal with just one simple fact. It is that ICJ accepts that a military forces acting on the defense, retreating from the combat action, can in fact destroy private property, civilian property, to stop the attacking forces from getting access to those facilities. That has been stated, for instance, in the case US versus hostage in 1915. And addressing the second point, members of the tribunal, that still does not change the fact, members of the tribunal, that the damage sought by claimant are bank loans. Bank loans are not it's not a bar of gold. It's something that claimant would have to repay. It would not become its property. Thank you.
Thank you very much indeed. Well, what can I say? Congratulations, everyone, for having made it to the end of the final round. We, I think, are meant to retire, aren't we? Yes.
You are.
Okay, we're retiring then.
So different from previous round, the tribunal leaves the room. You can all stay, probably start the award ceremony shortly while the tribunal deliberates.
When do you want us back?
Well, you can take as much as you want. Well, maybe within the next 48 hours. But we will announce the winner and also the best advocate. So that's your two tasks. Winner team.
Winner team and best advocate.
Best advocate.
Okay, very
in
good.
the final.
Very
We'll
good.
announce those two as part of the award ceremony in a
Okay,
little while.
okay, very good.
Well done to everyone. It was a very, very high standard, and we've got
Thank
a
you.
tricky job.
Congratulations, both teams.
Thank you very much.
Thank you very much.
And opposing counsels.
Thank you for the round.
Yes, it was relatively quick with you. Thank you.
And thank you to you, opposing counsels.
And congratulations on getting here.
Thank you.
Co myślicie?
You need any help? Oh, no, okay. Yeah. It's kind of.